Good evening, friends. Today I intend to take up the subject matter plea bargaining, ideas and perception, and its practice from the ancient times, and to refer little detail in the context of USA and India. Now, it is interesting that the plea bargaining is an essential component of the administration of criminal justice properly administered. It also encourages and leads to prompt, largely final disposition of most criminal cases. The interesting part is this, that the plea bargaining is a legal mechanism wherein the accused agrees to plead guilty to a lesser charge or for a reduced sentence in exchange for concessions from the prosecution. Though widely recognized as a modern judicial practice, its roots can be traced back to ancient times. Uh, During ancient Greece and Roman times, in classical legal systems like Greece and Rome, there was no formal plea bargaining as understood today. However, informal negotiations and settlements between parties existed. Roman law allowed for compromises where disputing parties could settle matters outside formal trial settings, resembling early dispute resolution techniques. During the Middle Ages, English common law emphasized trials, especially by the jury, but accrued individuals could not merely be by pleading guilty. The benefit of clergy, an early form of legal leniency, allowed first time offenders to avoid harsh punishment by pleading guilty and showing repentance. In ancient and medieval India, legal systems, including Hindu and Islamic laws, encouraged reconciliation and settlements outside courts akin to modern plea bargaining. The Mughal judicial system allowed for pardons and reduced sentence if an accused confessed and showed remorse. During British rule, the Indian Penal Code IPC and Criminal Procedure Code CRPC primarily focused on trials with little scope for plea negotiations. It will be important at this stage to explain the different definitions that have been given by the different authorities about the plea bargaining. According to Encyclopedia Britannica, the plea bargaining in law is a practice of negotiating an agreement between the prosecution and the defense whereby the defendant pleads guilty to a lesser offense or, in the case of multiple offenses, to one or more of the offenses charged in exchange for a more lenient sentencing recommendations, a specific sentence, or a dismissal of other charges. Supporters of plea bargaining claim that it speeds court proceedings and guarantees a conviction, whereas opponents believe that it prevents justice from being served. The great majority of criminal cases in the United States involve some form of plea bargaining or the other. Now, plea bargains are not always easy to recognize. Negotiations that result in formal agreements are termed explicit plea bargains. However, some plea bargains are called implicit plea bargains because they involve the guarantee because they involve no guarantee of leniency. Explicit bargains are the more important of the two. Now, this is the one definition as given in the Encyclopedia Britannica. In the another, according to Black Law Dictionary, reference is dictionary edition 10, page number 1339, and it says like this that plea bargaining has been defined as a negotiated agreement between a prosecutor and a criminal defendant whereby the defendant pleads guilty to a lesser offense or one of the multiple charges in exchange for some concession by the prosecutor, usually a more lenient sentence or a dismissal of the negotiated charges. According to Oxford University or Oxford Dictionary, the meaning, the word plea means to appeal, prayer, request, or formal statement, or on behalf of the defendant, and the word bargain means negotiation, settlement, deal, covenant, barter, or pact. Hence, the word meaning of plea bargaining may be an appeal or formal statement by the defendant for a negotiated settlement with the prosecution for the offense charged against him. According to Warren Burger, Chief Justice of the United States of America, in the famous case Santobello versus New York, 1971, plea bargaining is an essential, I quote, plea bargaining is an essential component of the administration of justice. Properly administered, it is to be encouraged. It leads to prompt and largely final disposition of most criminal cases. According to Robert E. Scott and William J. Swans, an authority on criminal law, has explained like this: plea bargaining as a contractual agreement between the prosecutor and the defendant concerning the disposition of a criminal charge. However, unlike most contractual agreement, it is not enforceable until a judge approves it. Unquote. Now, this reference you will find in Yale Law Journal, 1992. Now, after explaining this concept and definition, let us come to the plea bargaining concept and practice in modern legal systems. Let us take up now the USA. In the United States, the plea bargaining became widespread in the 19th and early 20th centuries, particularly in response to increasing caseloads in American courts. The practice was formally recognized and expanded post World War II, becoming a cornerstone of the US criminal justice system. In a very famous case in Brady versus United States 1970, the US Supreme Court upheld the constitutionality of plea bargaining, affirming its voluntary nature. In another very famous case, Santobello versus New York 1971, the court ruled that prosecutors must honor plea agreements once made. Let us see the plea bargaining in the context of India now. Now, this concept was usually absent in Indian law due to concerns about coercion and injustice. The Malimat Committee report in the year 2003 recommended incorporating plea bargaining to expedite trials of reduce backlog reduce backlog of cases. Criminal Law Amendment Act 2005 in India introduced plea bargaining in India under sections 265A to 265L of the CRPC, applying to cases with punishments below 7 years and reducing serious and excluding serious offenses like murder and terrorism. In a famous case in the state of Gujarat versus Natwar Harchand G. Thakur case of 2005, the Gujarat High Court held that plea bargaining could be a significant tool for reforming the criminal justice system. It will be pertinent and necessary at this stage to compare the plea bargaining idea and practice in USA and India. The scope in USA of plea bargaining is applies to almost all offenses, whereas in India it is limited to less serious charges or crimes. Binding nature in America legally binding on courts and parties, whereas in India it requires judicial approval. The victim's role in America, this has limited influence, whereas in India victims' consent is crucial in certain cases. And in America, the legal safeguard is strong, due process safeguards are there, whereas in India it is restricted to prevent misuse. United States, while plea bargaining helps in case disposal, critics argue that it coerces defendants into waiving their trial rights. As far as India is concerned, there are concerns about fairness, particularly regarding weaker sections of society who might be pressurized into accepting plea deals. Now, if we see the, if let us try to see this plea bargaining in somewhat detail in the context of India. Now, prior to this legislative development, that is the Amendment Act of 2005, which added chapters 20A, sections 265A to 265L to the Code of Criminal Procedure, CRPC. Uh, Important feature here is this, that this chapter which has been added, it outlines the framework for plea bargaining, specifying its applicability to offences punishable with imprisonment up to 7 years, excluding offences affecting the socio-economic conditions of the country or committed against women or children below 14 years of age. Now, prior to this legislative development, the Supreme Court of India had consistently disapproved of plea bargaining. Now, uh, if we see that the, in the case of India, the earliest case in which the concept of plea bargaining was considered by the Honorable Court, it was Madan Lal Ramchandar Dugga versus State of Maharashtra. It is in the year 1988. in which the court observed and that it is very wrong for a court to enter into a bargain of this character. Offences should be tried and punished according to the guilt of the accused. And if the court thinks that leniency can be shown on the facts of the case, it may impose a lighter sentence. In another case, in Murlidhar Meghraj versus State of Maharashtra, 1976, when the appellant plead guilty to the charge, the trial magistrate sentenced them to a petty fine. The apex court, the Supreme Court, continued to disapprove of the concept of plea bargaining. Court observed, in this case, to begin with, we are free to confess to a hunch that the appellants had hastened with their pleas of guilty, hopefully induced by an informal, tripartite understanding of light sentence in lieu of narrow contendera stance. For a long time, the Supreme Court was hesitant to implement the concept of plea bargaining in India since it entails the accused bargaining his constitutionality given right to fair trial, leniency to punishment. I have already earlier mentioned about the Gujarat High Court case, which appreciated this procedure and observed in the state of Gujarat versus Natwar Harshanji Thakur case, which I have already referred earlier. The very object of law is to provide easy, cheap, and expeditious. I am quoting from the judgment. The very object of law is to provide easy, cheap, and expeditious justice by resolution of disputes, including the trial of criminal cases. And considering the present realistic profile of dependency and delay in disposal in the administration of law and justice, fundamental reforms are inevitable. There should not be anything static. It can thus be said that plea bargaining is really a measure and redressal, and it shall add a new dimension in the realm of judicial reforms. Now, these are, I have quoted from the judgment, and it is a very important observation, which has, for the first time, the Supreme Court has shown its tendency to approve the concept of plea bargaining. Now, in Murlidhar Meghraj Loya versus State of Maharashtra, 1976, the court realized and the court criticized the concept, stating that it intrudes upon society's interest. In another case also, similarly in Kosam Bhai versus State of Gujarat case, the court held that plea bargaining is against public policy. And in the state of Uttar Pradesh versus Chandrika 2000, the Supreme Court reiterated that criminal cases cannot be disposed of based on plea bargaining and must be decided on their merits. Now, here are both the case laws where at times the Supreme Court has tried to support the concept of plea bargaining, and however, and most of the cases they have tried to desist from it. Interestingly, however, in the latest 2022 year, 2022, in the case of the regarding policy strategy for a grant of bail, the Supreme Court proposed measures to enhance plea bargaining, compounding of offences, and the application of the Probation of Offenders Act to alleviate the burden on the criminal justice system. The court recommended that courts identify cases involving first-time offenders with offences punishable with imprisonment of up to 7 years, excluding those affecting socio-economic conditions or involving women and children under 14 years. Now, this indicates positively a shift in the judicial approach towards plea bargaining, recognizing its potential to expedite the disposal of cases and reduce the burden on courts. Now, this concept, this, but however, we still we find there are many other reasons. If we like try to see in what way, what are the reasons for the failure of the plea bargaining in India. Few of the important points here it can be mentioned: weight of pendency, state fighting the citizen, adjournments, and other reasons. Let us see what are the reasons why it is not neither why it is not so much effective, or for that matter you can say that why there is a complete failure for that matter, or the obstacles or handicaps in the implementation of the pre-bargaining concept in India. First point to be considered is the weight of pendency of cases. The present system of administration of justice, which is clubbing under the weight of the pending case. It is estimated that the number of the case pending all over country in all categories of court, it is staggering around 2.3 crores, and out of this 16 lakh cases are pending in the High Court alone, virtually clogging the justice system. The former Chief Justice of India, A.S. Anand, has observed that there are just 13,000 judicial officers who cannot cope up with the current load of cases, clocking and the whole system. It is pertinent to note that posts of judges of the various high courts are very often not completely filled up. Now, this constitutes 20% of the total number of the High Court judges is vacant. Now, if these posts are not filled in immediately, more cases will be piled up. So, it is because of this also that there is a problem. Another important factor is why the reason for the failure of the plea bargaining in India is that surprisingly, the government is the country's largest litigator. Approximately 70% of all cases are either against or appealed by the state, according to a rough estimate. At the expense of citizen, the state files a lawsuit against them. Another factor, which is the amount of the failure of the plea bargaining in India, is adjournment. Unnecessary or unnecessarily, adjournments also extends the life of the litigation. The practice of adjournments on the frivolous grounds is one of the major reasons to the increases in delay. While there is a very good understanding between the court and the advocate, the same does not exist between the client and the courts. In the process, the interest of litigant suffers. Judiciary fails to render justice to the aggrieved. There is a need to develop a set of criteria for granting the adjournments as well as framework for resolving disagreements. And other reasons we may be called as which are responsible for the failure of the plea bargaining in India is suggested a reduction in the matter in the number of is suggestion a reduction in the number of holidays of courts and increases in the working day of the courts. At present, the court working for 210 to 230 days every year with a fully long summer vacation. If courts work for long hours and days, litigation can brought under control. Now, if we see the another aspect of these are the reasons, but we have to see another very interesting point. The point is that if we see what is the possible scenario of future of the plea bargaining in India, the underutilization of plea bargaining suggests a need for increased awareness and acceptance within the legal community. Future reforms could focus on enhancing awareness, educating legal practitioners and the public about the benefits and procedures of plea bargaining, safeguarding rights, ensuring that the accused concerned is truly voluntarily and plea agreements are just and fair. And third, expanding applicability, considering the inclusion of a broader range of offenses under the plea bargaining provisions while balancing the interests of justice. So, by addressing these areas, plea bargaining can become a more effective tool in the Indian criminal justice systems, contributing to swifter justice delivery and reduced case backlogs. So, in the end, it will be, in all fairness, to state that the plea bargaining has evolved from informal settlements in ancient legal traditions to a formalized process in modern judicial systems. While the US has embraced it extensively, India has cautiously adopted it with legal safeguards. The practice continues to evolve, balancing judicial efficiency with justice. Thank you very much. But in the end, I must say that plea bargaining concept, its acceptance is has a very bright future in the Indian context. Thank you very, very much.